Welcome to the January webinar, Producer Background Screening, New Year, New Administration, New Risks. My name is Julie Mendel and I'm the Education Trustee for the SILA Foundation. Before introducing our speakers this afternoon, I have just a couple of housekeeping items. This webinar is 1 hour in length and is being recorded. Please put your questions in the chat box where they will be monitored for our speakers on your behalf. We'll address as many of the questions as possible in the time that we have available. Within the next week, you will receive a link to the recording with a copy of the presentation and a post-webinar survey that we would appreciate you completing. We have 2 speakers today to continue our annual discussion on the ever-changing landscape of background screening. Greg Kirsch, Chief Operating and Compliance Officer of Applicant Insight No More Forms, is an industry-recognized expert in background screening solutions and compliance with the Fair Credit Reporting Act in the employment, contractor, and volunteer screening context. Greg is a graduate of the Westchester University of Pennsylvania, holds advanced FCRA certification through the PBSA, and currently chairs SILA's Agency Carrier Background Investigations Task Group. Matt Brombeck is the Vice President of Sales at Business Information Group, also known as BIG. He's been deeply involved in the background screening industry for the better part of 24 years. Matt is a graduate of Grove City College and serves as BIG's subject matter expert on designing, implementing, and overseeing background screening programs for organizations operating in the insurance and finance space. Over the years, he has maintained positions on both the SILA and SILA Foundation boards and continues to be actively involved in several committees. Please join me in welcoming 2 of our most popular speakers, Greg and Matt, back to our virtual webinar stage.
Well, thank you so much. And welcome everyone. We will be covering several different topics today in what we were joking is the least frequent podcast on earth. We do this pretty much once a year, talking about background screening trends in the security and insurance licensing industry. What we will be focusing on today is establishing a background checks baseline. Matt and I were both talking quite a bit about just how many new members were at the SILA conference this past year. And there's just been so much changeover in responsibilities within some of the organizations that we wanted to make sure we covered some historical baseline. So we're going to sum up the FCRA in section 1033 along with a couple of other items in like 3 slides or less. So there's a lot that goes behind it, but we're just going to try to baseline that. We're going to cover some new laws, continuing movements within those new laws, aspects that affect fingerprinting, and then we're going to wrap it up with some just the privacy, PII, and other risk assessment things that are happening on pretty much a daily basis now. So I'm going to start off here with the Fair Credit Reporting Act, or the FCRA. It's been around forever, since the 70s. It was, well, I say forever, I've also been around since the 70s, but it was originally under the Federal Trade Commission. They've been a government entity for a very, very long time. And then about 10 years ago, the Consumer Financial Protection Bureau was created. And that's going to tie into some of the privacy stuff too that we talk on the back end of this, but particularly in relation to the new administration, new changes. That's going to be one thing that I'll be monitoring personally is, the Federal Trade Commission had all the rights over the Fair Credit Reporting Act as far as rulemaking and enforcement. But since the CFPB came into play, only one party has the rulemaking while the other one is responsible for the enforcement. Not sure if that's going to be considered government waste, if some of these things might be switched around. So there's a lot of dialogue around that. I don't really think consumer protection, consumer reporting, things like that are a target of the administration per se. I think there's much bigger items, but over the next couple of years, it will be interesting to watch how that plays out and if there's a power struggle. Something I want to mention specifically around the Fair Credit Reporting Act, and this is the highest level summary I can even provide here for an end user being a party that receives a background check. You have to have a permissible purpose. There's a whole bunch of them listed in the Fair Credit Reporting Act. 9 times out of 10, if Matt and I are talking about it, the employment purpose is, or the permissible purpose is employment, because employment's a very broad term. In the FCRA, as it's being applied, contractors, volunteers, everything kind of falls under employment. There are some exceptions, but you have to have a permissible purpose. You have to provide proper disclosure to a person that a background check will be run, and you have to obtain their authorization to run that background check. And then if you're going to eliminate them in whole or in part from whatever that benefit that they've applied to is, you have to follow certain adverse action procedures. Each one of those bullet points is something that I could personally probably talk about for 30 minutes. Most of you would just probably start multitasking at that point, so I'm not going to go into that. But just for the high level summary there, that's what you have a responsibility for when you're running background checks. Unfortunately, neither the FTC or the CFPB have issued, sample language or anything that offers any type of safe harbor. So there's a lot of legal interpretation as far as what that disclosure needs to be, when that authorization needs to happen, and other things around that. Matt and I don't offer legal advice, but we do, consult on this type of stuff quite frequently. On the backside of that, an organization like Matt's or mine, where we're providing the background checks, we are a consumer reporting agency. So we have a whole set of responsibilities. The main ones that I think are important to this conversation are to maintain procedures, to ensure the information is accurate, up to date, and from the best possible source. I'm merging a bunch of things in there into that sentence, but generally, we have a responsibility to make sure that what we're reporting is accurate to where we're getting it. We have to limit certain reporting of information. The Fair Credit Reporting Act limits non-convictions and other adverse information to 7 years. Conviction reporting is unlimited in its scope. And you may have heard certain things fall off your credit report after 7 years. It's because of the Fair Credit Reporting Act. Bankruptcies can stay on the credit report for 10 years. It's because of the Fair Credit Reporting Act. And then also, we have, as a consumer reporting agency, a responsibility to process the consumer dispute. So if someone's disputing that what we reported is inaccurate, we have to take care of that. And there's a whole bunch of rules there. Now, again, that's a very high level baseline summary of the Fair Credit Reporting Act. I think that was maybe 6 minutes. I don't think I've ever talked about the FCRA for 6 minutes or less before. So
it's very, very, very succinct.
yes.
One thing to add, and to comment on, FCRA, while credit is in the title, a bit of a misnomer, it encapsulates anything that you're procuring through a consumer reporting agency. So PDB information, criminal information, credit, obviously, regulatory sanctions. So while credit is referenced specifically, this is a broad requirement. And so even if you're just pulling some civil disclosure information or doing a very basic public record criminal research, FCRA applies. It's not so much public, and public is public. It's how you use that information, for what purpose you use that information, is how you then fall, under some of these guidelines. We'll talk a little bit more about how that applies to fingerprinting and some other areas.
Yeah, and also importantly along that same line, you don't declare as an end user. We don't register as a consumer reporting agency. You and we become these parties just merely by the act of doing what we do. The fact that we compile information from multiple sources and make it available to you to make a decision on a candidate for one or more permissible purposes, that at that moment defines us as a consumer reporting agency under the Fair Credit Reporting Act. All of these are arguments. There's always an argument against in some scenarios, but the FCRA itself's been pretty well litigated, unlike some of the ban the box and clean slate stuff that we're going to talk about later, which is so new that there's not a lot of case law to really determine what is and isn't in line. Now, I'm going to talk a little bit about the 1033 requirement. This is particularly on the insurance side. So carriers, anyone that's that's onboarding or maintains a pool of producers, the Section 1033 of the Violent Crimes Control and Law Enforcement Act of 1994. This is why the act is called that. I have no idea. It has nothing to do specifically with what we're talking about, but this is where it is, and it specifically mentions that anyone in the business of insurance has to ensure that an applicant has not been convicted of any felony involving dishonesty or breach of trust. So, and it also carves out very specific entries about insurers that allow producers under the above to proceed may be subject to criminal charges. So the crimes of felony involving dishonesty, breach of trust, fraud, it could be, there's a whole group of things that are generally, considered to be within that realm. A state can issue, at the time that a producer is requesting a license, they can issue a 1033 waiver, because a producer will go through a background check process with the state when they're actually getting their license. That is separate and independent from what typically you as a carrier or someone that is working directly with these producers would apply. But a state can issue a 1033 waiver to a producer, meaning if that person happens to have something that would fall under the 1033 requirements, but they've reviewed the time since, the nature of it, some other factors, they can issue a waiver to that individual. But I also do want to point out that while it stands to reason that you might want to honor that, I do want to mention that as a carrier or someone that's engaging in or onboarding that potential producer, you are not obligated to honor that 1033 waiver. So if you run your own screening process and get information back, and they provide a 1033 waiver, you should definitely consider it, but you are not obligated to honor that and onboard that producer as a result of that. And also those 1033 waivers are the non-issuing state, so someone that's applying for a license in a different state, that second state does not have to honor the waiver that was issued by the issuing state, if that makes sense. So it is there is some states that generally work together on these things, but Matt and I wouldn't have background check programs in the insurance carrier business if we didn't, just as a matter of practice, routinely identify information that may fall within this, that ultimately wasn't caught in the licensing process, occurred after the license was obtained, any of those other factors. And also, there's a whole host of other histories. So there may be other criminal information associated with a person that may be a violation of your onboarding practices, how it relates with HR or anything else. Murder is not a felony involving dishonesty or breach of trust. There's arguments that you can make it, but as a general rule, they're looking for fraudulent type events. Now, on the other side of that, on the security side, Matt, I'll hand this one over to you, because this is, just to be transparent with the audience here, Matt just inserted this slide last night and I haven't even looked at it. But so please, Matt, go ahead. This is a podcast, not a webinar, right? So go for it.
I like to slide things in to keep you guessing. I also mixed around some of the other stuff just to see if you're paying attention.
I'm on my toes. I got my dancing shoes.
Excellent. So, and much like there's a driver for the insurance side of the house on 1033, likewise, FINRA, SEC, there's rules, there's regulations that kind of drive the responsibilities of firms to ensure that the individuals that they are onboarding, that they're registering, that they're supporting, meet minimum expectations of the industry. There's a fingerprint requirement. Any registered representative, any associated person has to go through a fingerprint process. But a rule that came about, let's say 10 years ago or so, 3110E, really kind of articulated, FINRA's expectations in terms of, what they want you to do in terms of a representative verifying information on you for. You want to make sure the individual has good character, they're a good reputation. They don't have regulatory sanctions. Disclosure issues are documented, maintained, updated as appropriate. So it basically requires some review, some due diligence to ensure the information that's being filed with FINRA is correct and accurate. And as such, there's a 10-year work history and employment history on the U4 that needs to be verified. Civil, making sure there's no bankruptcies, tax liens, judgments that have been filed that weren't explicitly documented. Financials are reviewed. Compromise to creditors are a big element. Regulatory sanctions. Key element in the onboarding is criminal. And while the 3110E does express, you can use publicly available database, national database sources to do kind of pre-screening and pre-vetting of individuals. Largely the fingerprint is the gold standard that is required, as part of the onboarding process. And Greg, if you want to slide on, into the next one, it just speaks to, some of the nuances associated to fingerprinting. What Greg kind of walked through on the FCRA and 1033, that's all public record information. When you're arrested, that crime is handled, heard in either a state or a federal district. That information is ultimately reported up through the FBI database. And so running a fingerprint through the FBI is wildly comprehensive, in terms of data, in terms of information. And that's why it becomes the gold standard. That's why there's regulations around these industries, NFA, FINRA, and MLS for the mortgage industry, where laws and rules are written in to ensure fingerprints are accessed as part of the onboarding. Now, it is a bit of a different animal. It requires individuals to get fingerprinted. Those fingerprints are processed directly with the FBI. The results get returned back to the regulatory body that has as an appropriate recipient of that information. Fingerprints from FINRA, required for registered reps, associated persons, anybody kind of touching the process and leadership. It's also done on the insurance side. Certain states require fingerprints as part of their initial licensure. Some do so for resident licenses. Some do it for non-resident licenses. It's not guaranteed, though. Not all states require that. And so organizations that are looking to design a policy and program around a comprehensive due diligence process, you shouldn't rely upon what you expect a state to do, perhaps. The 1033 puts the responsibility and the onus on the carrier, on those that want to do the business of insurance. So certainly keep an eye out for that. FINRA utilizes a channeler. That's an outsourced software provider that coordinates all of the fingerprints. Not just anybody can do fingerprints. So if you're an investment advisor and you want to do a similar program that you do on the FINRA and security side, it's just not available. The FBI heavily regulates fingerprinting. Only those that have a federal law, there's a federal act that permit or require the prints, and within that, define who can process. And securities industry, FINRA, has been that designee. Now, fingerprints can be done either electronically. They can be done through print cards. There is an establishment network of third parties that are referred to as EFS providers, electronic fingerprint submission providers, that work directly with FINRA's software such that fingerprints are captured and facilitated electronically. So back, 15 years ago, where fingerprints were largely captured by paper going into police stations, wildly different in the current state. And as such, fingerprints are processed generally between 20 and 30 minutes. Now, there's a big difference between what FINRA permits on the US sector versus non-US. Different processes have to be fulfilled. EFS providers can't step in. There's a coordination of print cards. So there's a whole lot of different layers associated to fingerprint requirements. But all of which is a necessary evil, to ensure the folks that are entering in a heavily regulated industry have had some due diligence against them.
Okay, so now it's going to get weird because all we've talked about is what's always been in place. We haven't really talked about any of the new variants. Now we're going to get into some of the new variants. I want to talk about.
Sorry, Greg. Before we jump in, there were a couple of questions that have popped up here.
Did see some of that coming in. Okay.
Yeah, do you have examples of crimes that fall under dishonest or breach of trust? I believe correct me if I'm wrong, Greg, it's a big nebulous.
It's big, it's huge. It's
Um,
theft,
there have been,
embezzlement, fraud.
there have been some organizations that have, within their designated industry, I believe NMLS may have provided a list at some point or another. But it all becomes very subjective. And even if you get a list or a list gets passed along, it's going to be a very subjective decision as to what really constitutes dishonesty or breach of trust. I'll add to that, 1033 specifies a felony of dishonesty or breach of trust. There are states, New Jersey, nothing against New Jersey, but don't necessarily have quote unquote felonies or misdemeanors. They have levels of crimes. And so, from a policy perspective, you want to, belt and suspenders, you want to take a very conservative approach to that, which we're very much in an industry of conservative. But it's something that you really want to take a look at, define and document, because you want to make sure that your decisions are consistent. Greg, I don't know if you want to opine.
Yeah, I mean, I believe, like, I want to say Florida, at least for a long time, like a bad check of $500 or more, like a check that bounced, was actually, classified as a felony. I want to say it's Florida. I've quoted some of that in the past, but those are the types of things where typically I'll see a 1033 waiver being issued and a producer will have it because from a technical standpoint, it's a felony and it's involving theft or dishonesty just in the act and nature of a bad check. But because that same offense in another state would be a misdemeanor and it was 20 years ago, they may issue a 1033 waiver. So that's the kind of stuff I see. I mean, I personally can make a lot of arguments as far as what's dishonesty or breach of trust. I would assume that if I'm walking out the door today, nobody's going to murder me. And if someone murders me, they're breaching the trust that I'm not going to be murdered. But that's kind of a stretch argument. But so again, it's a very, very open concept. Yeah, I could go into many details on that, but that's generally what we're seeing. It basically, if it seems like someone was the victim of a misrepresentation, it's going to fall into that. So any types of fraud, embezzlement, forgery, things like bad checks, so those scenarios I think typically all apply.
Yeah.
So fair chance acts, these are something that you'll see more and more often. We're continuing to see them in the news. There's a whole host of generally what would be considered employment law firms that are kind of focused on how to navigate these things. Just by the nature of the business we're involved in, we, adapt to different practices that are being, requested by the end user, but of the background checks. But a Fair Chance Act or ban the box law, depending on how it's framed out, is going to be very different from a Clean Slate Act. And I'm going to try to demonstrate the difference between the two. But at the highest level, they're passed at all sorts of levels. There's states pass it and they'll have their own language about what can and cannot be considered. A lot of the content within these laws typically reflects. There was EOC guidance in 2012 about how criminal history should be used in employment decisions, mostly because of the disparate impact on certain protected classes. Generally, what they ask you to take a look at is the age of the offense, the age of the individual at the time of the offense, the circumstances around it, the number of offenses. There's a whole bunch of factors. They call them the green factors. It's its own webinar unto itself to do that. But generally, there's EOC guidance 2012 that tells you how you should and should not, as a employer or pseudo employment type party, be considering this the information on candidates. The common thread too also in these is about there's always something about when you can ask. This is where the ban the box term comes from. The idea being you can't ask if someone has criminal history or run a criminal background check at the time of application. They don't want you to just immediately disregard a person because of just the mere existence of criminal history. The general construct is an interview, a review of their credentials in some way, shape, or form, and then conduct and or inquire about criminal history, as well as if there is criminal history, provide a period or a means for somebody for you to assess that on that individual's basis. They call it an individualized assessment versus just a blanket policy. We don't hire people with criminal history. We don't, that kind of stuff is a direct barrier towards and statistically leads to recidivism within the criminal community. So there's also a lot of unique adverse action requirements, adverse action being the sequence of events that you have to take if you're going to eliminate someone in whole or in part on the background. The thing about these laws most recently, and I'd say over the last 2 years, is they're very specifically starting to call out non-traditional employment. So they will call out contractors, volunteers, things like that. Another thing that you'll have to navigate as you go through them is the law specific to, say it was passed in Los Angeles? Is it specific to residents of Los Angeles? Is it specific to employers in Los Angeles? Is it specific to, does it cover both? Or what if someone's going to be working in and out of Los Angeles? Unfortunately, the answer is all the above there, but each law is written differently. So as much as having a federal law like the FCRA can be difficult to navigate, the only thing harder than navigating one law that may or may not be poorly constructed is navigating 50 states worth of laws, as well as individual city, municipality, county type laws. And there's almost, because of how new these things are, there's very, very little case law as far as what is right, what is wrong, what is the guideline. So right now, the general obstacle or the general goal is to try to comply with the acts that are being passed, but also not be the poster child for it. So, there's 35 states currently, just over 35 states that have some type of Fair Chance Act law on the books. There's 150 plus county, city, municipalities. Illinois and California were the two most recent large states to pass their own kind of statewide comprehensive fair chance law. But again, just to be I use the term poster child again, California, even within California, Los Angeles has its own, San Francisco has its own, San Diego has its own. San Diego and Los Angeles state that it applies to the unincorporated San Diego County, or the unincorporated city of San Diego, or the unincorporated city of Los Angeles. I would wager most people that even live in the greater Los Angeles area would not be able to tell you whether or not they're in the unincorporated Los Angeles area or not, because it's not zip code driven. So it's another imaginary line on top of 3 other imaginary lines that make up the map of that specific area. But what I can tell you is you don't want to be inquiring or running any type of background check until some type of offer or to onboard, to move forward, and the progress has been made. That's definitely a uniform application in these. I would also, in my experience, state that you should definitely have like a pre-adverse and adverse action process with individualized assessment, meaning when you're reviewing the background, you're sending out a pre-adverse action. In that, there's a chance for them to provide information back specifically related to criminal history. That seems to be the general focus here. And also, once a final adverse action is ready to be taken, you have those letters documented. If you're not working with outside legal counsel on what this content looks like, organizations like mine and Matt's, we have templates that we provide, but they're not legal advice. Generally speaking, you're going to want to have legal advice. I could just about guarantee the HR side of your house, the employee onboarding side of the house, has content around this stuff. So I don't know if you want to reach across the aisle there within your organization to sync some of that up, but it would be wise. And the other requirement is when you have those individualized assessment, I shorthand the IA, you're storing that information. So I have a link here, National Employment Law Project. They track all these ban the box things that are being passed and how they're relating. But the main points I want to mention just around the points of navigation when you're trying to go down this slalom course of compliance with, and this does apply to producer onboarding based off of the way this stuff's being written now. You need to look out for the laws, and when they say, does an employer have 5 or more employees, 7 more employees, and are located in the unincorporated area, that's the language you want to look out for. You want to look out for that individualized assessment has to be written. It has to be provided to the producer or potential employee or captive producer, and you also want to store those results. Some of them have a 3-year storage requirement. Some of them have a 5-year storage requirement. You want to make sure that the individuals have the right to submit evidence of rehabilitation, which is typically done throughout the individualized assessment process. The laws, I have this is an exact kind of carve out of one of them, covers contracted, commissioned, or part-time work with or without pay. So we're talking volunteers, we're talking coaches, we're talking all sorts of different parties are being covered under this blanket employment context. San Diego specifically, on the adverse notice, you have to provide them with a right to file a complaint with the San Diego Office of Labor Standards and Enforcement. It's just a sentence, put it on there. Same with Los Angeles. Well, Los Angeles has another thing where they get 5 days to respond, and then if they respond, then there's 10 additional more days to review that, and then a final action with a second assessment. This is getting very, very complicated, and each state seems to model its one off of a previous state that was said, but so we'll take these 5 things, and then we're going to put 2 other little things to make this our special little thing, put it out there. And importantly, the fines range from, you know, 5,000 for first offense to 20,000 for third offense. Some of them have clauses that allow civil action, which then allows someone to show harm. And those show harm things, a lot of the FCRA case law comes into play, and that can be pretty substantial. So, yeah, fair chance, ban the box. These things, if you're not paying attention to them, or if you don't subscribe to some of these blogs or have outside counsel that's feeding you something around this stuff, I would highly recommend that you do so, because you know, the insurance securities is not so much affected just because of the FINRA involvement a little bit more, but as a general rule, you know, the insurance you know, industry producers are a pretty hard target to hit, just because there are a lot of complex laws that are coming together that around these producers versus a standard employment scenario. But that doesn't mean that someone's not going to be the poster child for it. So,
Yeah,
Matt,
plus,
I just went on a diatribe. I don't know if you even had anything on fair chance.
no, I would have stopped you. I would have stopped you along the way. But I mean, you know, the importance of compliance is on all fronts, but, you know, keenly in this arena, because, you know, these are individuals that you're denying. They're probably going to be upset about it. These are people that have probably been through the system. They know they have an issue, and they're sometimes looking for organizations to trip up, not to include something that they should. They live in an area that I have these rights, I have more, I did something somewhere else. Now I live here because I have more rights. So, you know, while, you know, throughout the dialogue that we're having today, all of these are very important elements, you know, from a compliance perspective. But, you know, some of these where you're potentially, you know, denying somebody, you've got a jaded individual, you know, they're going to press buttons. So make sure you've really reviewed your policy and your procedures. And that's very challenging with national carriers, where you've got agents all over the country living in all 150, you know, municipalities. So I can't you know, press, you know, the importance of this enough. It probably happens very infrequently. You probably don't deny folks and agents and brokers all that often. That just makes this even more important to make sure you have all your ducks in a row, you know, basically.
And it does help that you're working with a pre-screened population to a certain extent, because a lot of these individuals have gone through a licensing process. But we talked about that licensing process is only looking for certain types of history. There's a whole slew of other history that shows up when you run, yeah, your producer screening just around your own practices. So yeah, the risk is there, though it is not as extreme, obviously, in insurance environment or even securities environment as it would be in, you know, warehousing and direct, you know, kind of labor environments. Now, that was all the stuff you have to be on the lookout for. I do want to talk a little bit about clean slate laws. Fortunately, you don't have to do anything. You don't have to do anything about clean slate as a general rule, and we don't have to do anything about clean slate as a general rule if all goes according to plan. Clean slate laws are passed at individual state levels, and what they do is they permanently remove what are generally low-level qualifying offenses from the record book. So think of it almost like mass expungement. A perfect example of where these things are being applied, and it makes logical sense, is if you have a state where marijuana has been decriminalized, why would someone's possession of marijuana from 10 years ago be a relevant item on their record if their possession of that same exact amount, quantity, whatever it may be, would not even be a criminal offense today. So several states have passed these types of laws where they go through a clean slate process. They identify the types of offenses, typically low level misdemeanors, some things like THC, marijuana related offenses. There's typically a carve out for things like distribution and stuff like that because that's kind of a whole different animal. But they'll also just remove other things. Someone that has just one misdemeanor in their past from 15 to 20 years ago, and it's a low level misdemeanor, and there's been no activity since. They go through a process of expunging, which the idea of an expungement is to permanently remove the record from from public view. When these laws pass, there's typically a 2 to 3 year tail on their implementation because it is a complex task. Um, Generally, you don't need to be concerned about severe offenses going away. The stuff you would look for under Section 1033 or anything else are typically not eligible for clean slate expungement. They're identified, and this is where kind of the hierarchy of the systems in play come in, but they're typically implemented within a state repository. So for Texas, could be the Department of Public Safety. They're going to look and identify all the records that they have in their repository, and then they're going to point down to each of the individual counties where it may be located and tell them you need to remove it by this date. That date could be 2 years from now, and ultimately information would be purged. Federal courts, I do want to mention federal offenses. Federal courts are typically not included in this process. The federal courts are a federal program. For those of you that aren't really too tied into the way this stuff works, across the 50 states and U.S. territories, there's about 3,600 individual county court or court equivalents that have a county seat courthouse and all the other stuff, the sub courts within them. At that exact same time, there's certain federal courts. Every state has at least one federal court. If you've ever been called for federal jury duty, I'm sorry, that's a big deal. You have to probably drive far to get there. But like New Jersey is a pretty large state, only has one federal district, one federal court. Some states can have up to 4, I think, federal courts. But again, we as consumer reporting agencies, you as end users, don't really have a direct role in this process. The only thing that I'd see coming up is for me, for Matt, and for many of you, I'm sure it's not uncommon for us to screen the same producer multiple times over a period of time. Sometimes it's within the same carrier upon a renewal every 2 years, some scenario like that. Or we might screen one producer that is not a captive producer for one carrier, and then another on or around the same time if they're selling Medicare or something along those lines. So we'll have multiple background reports in our system, and where this kind of messes up that process is if we ran a background check last year on somebody and reported a fully reportable misdemeanor event, and then we run that same person tomorrow and that's not there and a clean slate act had been initiated, it's very difficult for us to get confirmation from the court that something that's not supposed to exist that did exist and didn't, if that makes sense. Like we have to figure out, was there a miss here? Is this misfiled? And sometimes the best we're going to get is expunged cases no longer show on public access. It's just a generic term, and that's kind of like, oh, okay, that's what happened. So there are 12 states that have clean slate initiatives in place today, but many of them are in different stages of their rollout. But I think what's kind of most important here is the application of this is messy at best. And I say that because, and here we go, everybody pay attention. This is a diagram. I wrote this diagram just for this webinar. So this is a big deal. This is kind of a simplified version of the way criminal court proceedings work and how things happen. So you have a starting point of an arresting agency. Somebody's arrested for something. It could be arrested by state police. It could be arrested by the FBI, whatever it may be. Ultimately, if it's a federal case, meaning it's the United States versus that individual, it'll go to the federal court system. If it is a non, if the FBI does not have jurisdiction, or the federal, if there's no federal jurisdiction over it, then, and the state takes it, it will be the state of Florida, state of Pennsylvania, state, or Commonwealth of Pennsylvania, state of whatever it may be, versus that individual. These are the court systems where criminal history is tried, housed, and I mean, there's little small exceptions. There's military courts, things like that. But as a general rule, it's these two places. Criminal history is going to be tried, disposed, and have a, sentencing determined within these two areas. What gets kind of weird about this after this point is if it takes place in that county system, every state has a repository. And this ties a lot into what Matt was talking about with fingerprints going to states and then to the FBI. But the county courts will report their information to the state repository as a general rule. There's a lot of gaps in it. And I also want to point out that at the same time this county is trying to report event 1, 2, 3, 4 to the state repository, that arresting agency probably also reported that arrest to there. So they have to sync those two events up. Sometimes they get orphaned from one another. It can get very ugly. And in addition, anything that happens in this federal court system, I hope you can see my cursor. Matt, can you see my cursor, or am I going? Okay,
Yep.
Wrong time to ask the question, but good. I'm glad you could see it. At least it shows where I'm pointing. So if it's at the federal court system, all this information ultimately would report into the FBI database. So, but it goes all the way around here to get to the FBI database, and it goes all the way through here to get to the FBI database. And at the same time, that arresting agency information may be reporting directly to the FBI database. If it didn't report to the state repository, then to the FBI database. So it's all sorts of messy. And then all the way on the back end of this, you have all the prison records and probation and parole departments in the individual states. You have the watch lists and sex offender registries, debarments, all these other list programs that may or may not be feeding into these different repositories at different, whether state repository or federal. And all the way outside this process, there's this little crawler, this thing that the background check companies use called the National Criminal Database. And what that's doing is that is just constantly querying information from all these systems. What's available online? What can I compile? What can I put into a database? What can I make available that then can be searched and indexed to supplement direct searches of the individual sources? So the reason this gets so messy is when this state repository needs to clean slate something, they're telling the county, I need you to purge all these records. The county says, okay, I'm going to purge this record. The problem is they're not just telling one county, they're telling 40 counties, 80 counties in that state what they need to purge out of the system. It doesn't mean the arresting agency has purged it. It doesn't mean the prison records have purged it. And it also doesn't mean it doesn't continue to exist within an FBI database on a fingerprint. So, there's limitations in this process that can get very, very messy. So the clean slate idea makes sense, but its application is very buried in a bureaucracy of duplicate and out of sync data conditions. So now, Matt, how do you make sense out of that in relation to the fingerprinting? That's really the next stage, because all I did was scratch the surface.
Yeah. So, and it gets even more messy at this stage. So, where Greg was pointing out, the states are feeding data into the FBI databases. There's kind of two subsets of states. There's a subset of states in which they're kind of an offline. They're feeding the FBI database, and they're sending it routinely, and the FBI now has this in a particular database. There's other states that are in a live real-time scenario with the FBI in which you you submit a request to the FBI is going to ping that state for the state's most current information. And so, while some of these state clean slate scenarios have a big impact on timing, where Greg mentioned that it could be several years in which all of the different layers kind of fit them out. It adds a layer to some states with the FBI, and others, a state controls the data that the FBI sees. So where some of it becomes a little bit more messy, some of it does become a little bit clearer and in more control of the states and the state's reportability, simply because the FBI's real time, getting information from the state. Now, some of that also depends on how the state's law is written. They may have stricken records from the public system, but the criminal system to which the police agencies access, the FBI accesses, information still exists. So you may do public record research on the front end. You may end up filing paperwork, a fingerprint is done, and something's going to pop up. Something could very well pop up. You may see those results. If your insurance or securities and you're tied to a bank, the bank entity may be getting those FBI results directly and may be using that for employment decisions. You may get some information back through FINRA as well. So a lot of different things to consider, when the source, the data used to verify the information, there's so many different layers, so many different variations that it's important, that you have a policy documented and you have the right expectations going into it on what it means to you as an organization from a cost versus risk versus comprehensive program perspective. Just some changes, from a fingerprinting perspective, throughout last year, FINRA, their software provider, Sterling, has moved EFS providers into a new API. They've been tweaking that API over the course of the year, how to handle errors and responses. Things are, I think, getting into a really good place, in terms of that. We were seeing large spikes in terms of denials, in terms of rejects. Key and point, the fourth bullet down, the eligibles and pre-qualifications, is a step specifically that FINRA goes through, validating information before actually processing the fingerprints with the FBI. They've changed how they envision the pre-qualification rejects over time. Even so, there's still outside conditions that drive things. This time of year, people's fingers are cold, frozen. Winter has a wildly different reject and eligibility process than, say, midsummer. So it's very interesting to see the dynamics of how simple weather systems affect things like fingerprint processing. One element that was announced last year, NFA, is moving to an electronic fingerprint process, something that will be distributed and rolled out probably mid-year or so. So everybody should keep an ear out for that. I'm sure at the upcoming conferences that will be discussed. One of the questions came about of transfer agents. So one of the things that I spoke about earlier is about there's a law, there's a federal act that allows or requires fingerprints to be processed. For transfer agents, a similar requirement, you have to be fingerprinted. Now, in their law, it directs, there is an authority that will be designated to perform the functions of channeling. FINRA, it was chosen for that. Now, because FINRA doesn't want to intermingle FINRA stuff and security stuff and transfer agent stuff, they have two bifurcated process in which everything goes through EFS providers. From a securities perspective, there's a very defined process, around fingerprint facilitation on the security side. Likewise, on the transfer agent side, it is controlled by Sterling. They're capturing or they're receiving the fingerprint to channel and process, but it's separate and disjoint from the normal stuff that FINRA does. Now, you don't have to use Sterling to collect the fingerprints, but those fingerprints do have to be captured on Sterling branded cards. Those fingerprints do have to be processed and sent through Sterling. But you can have different collection points. You can have different parties collect those fingerprints. You can collect those fingerprints yourself, as long as you're following and facilitating through the account that you have through Sterling. And then finally, the FBI routinely goes through changes to their security standards. There was just an announcement that's going out this week of some changes. They've been talking about simplifying their security requirements. This has to do with the receipt of criminal record history. So largely doesn't affect you if you're simply capturing and processing for insurance licensure, or you're using FINRA. And as long as you're not storing that criminal record history or maintaining it in a non-channeler fashion, probably won't be directly related to you. But there are more of a simplification of those standards that are being distributed out. So busy time, but it's all data, right? There's it's not just, can you do a fingerprint? Can you do a background check? It's, where's that data at? How is it maintained? How is it stored? Greg and I routinely now go through risk assessments, and we love them because it makes everything secure. All the PII that we have to do, social security numbers, which are evil words. It requires organizations to get a very detailed and comprehensive documented security policy. That policy has to be able to maintain risk levels of data. Just because you have a name, you tie it to an email address, now it becomes PII, or a social security number or date of birth. Things on their own have different context than when combined with other things in a particular record. And so all of these have to be considered, audits reviewed, maintained, to ensure internally you're applying the appropriate standards for the information to which you're storing. But that also translates over to who you work with. Working with Greg, or working with myself, or your vertifors or reg eds, or any of the sundry of licensing. They have your information. They're using your information. Your policy now applies to them. They may be working with other third parties. They may not have fingerprinting, but may outsource to a third party. They may not have access to all of the same sources. They may access that through third parties, which they're third parties, which now become your fourth parties. So it's all of the things that we kind of talked about in terms of making sure you have a comprehensive background screening. You have to abide by fingerprint requirements and such. There's a whole sub-layer of risk associated to simply the information that you're now maintaining and storing. And sorry, Greg, I just went straight on through that. So please add some commentary.
You've been on mute the whole time, Matt. But anyway, sorry.
I tell my best jokes on mute. So
Yeah. I mean, personally, I'd love to lobby for just one security assessment to rule them all, so we don't have to reply to 40 of them, 50, 100 of them a year. Beyond just the stuff that we go through as organizations, but for whether it be PCI, SOC 2, all those types of kind of security credentials. But something else I do want to mention here is this is probably where I would expect the CFPB to be far more active going forward, and to arguably look for some wins to justify their coexistence with the FTC. Again, FTC's been around forever. CFPB's only been around 10 years. But if the Consumer Financial Protection Bureau focuses more on protecting consumers in the identity space, the privacy and data protection space, that would not surprise me at all. And that I don't know exactly what that would play out as, but that is protecting just the general consumer, the consumer being a TikTok user, or any profile that you might have just as a generalized consumer, not a background check type related consumer. I think that is an area where we might see some continue, or maybe a point of emphasis, particularly around the CFPB, more so than historically. I do want to mention too, we're pushing right up against time. Matt and I have been involved with the background investigations task group for me, I'm at 12 years, maybe something like that. So I don't know, you're probably longer. Actually, that just made me think of something. We did lose somebody last year, Paul Willis. He was a dear member to the SILA community. This is the first webinar that I think I've ever done for SILA that Paul wasn't attending. He was always very engaged in this stuff and engaged just in the organization. In my experience, I always felt welcome around him and encouraged to continue to do that. So I do want to take just a moment personally just to thank Paul for everything that he did for SILA and just his commitment to the industry in general. And particularly, he used to love this thing. We started doing a survey out of the task group in 2016. We did it 2016, 2017, then we waited 2 years. I think we were tired. So we did it 2019 and 2021. 2021, it was, the 2020, 2021 kind of COVID era is the last time we did this, and we presented it in 2022. What we generally try to do is compile 25 to 30 questions of the SILA membership, just to, Matt and I have talked about the term best practices. We don't love the term best practices necessarily, but at least gauge what the industry practices are over the years. How often do you screen producers? What are you screening for? What are the products and components in there? Usually we have 100 to 150 respondents. So anytime we do this as a task group, we are looking to do this again this year and maybe present, end of the year or beginning of next year. So if you are interested in joining our task group, people join listen only. Sometimes, you can participate, but we've done this in the past. It's posted on the SILA website. We've done webinars around it. It's typically well received, and for data people like me and practice people, it's fun. So I just wanted to, I guess I'm right up against time here, so hopefully I wasn't on mute that whole time, Matt. And
No, I heard you.
All right.
There was one last question that we didn't get to, and it was regarding reporting limitations. Greg mentioned it, as part of Clean Slate. There are reporting limitations around public record information. Some, most are limited to 7 years. Non-convictions, pending cases, non-criminal, so civil research, largely 7 years, except for a few bankruptcies. Criminal convictions are unlimited. So if there was a crime that was found 30 years ago, it is absolutely reportable. For the most part. There are some states that further limits, those to 7 years. So organizations like Greg's, mine, as we're doing research, we're always validating against federal law, state law, reportability of information based on known information within the case. So it's a quagmire of different layers, and that's kind of the benefit of outsourcing rather than running internal database sources and trying to vet through things on your own. Those are key elements that outsourcing brings to the table.
All right. Julie, over to you. I think we're done. We could, as you can see, we could probably talk for another hour if we really wanted to, and field a whole bunch of questions. But yeah, let's leave them wanting more, I guess.
We do love to hear our voices.
Yeah, we do. We're very, very egotistical.
Well, thank you both so much for sharing all your expertise and your knowledge with our group today. We really, really appreciate you, and we love having you on our webinar schedule every year. Everybody, we hope to see you at our February webinar where we will receive an overview of the securities industry. And remember that our webinars are public, they're free of charge, and sharing our invitations is greatly appreciated. So watch for and complete the post-webinar survey, and we will see you next month.